Now, the High Court has declared as unconstitutional a directive issued by the National Security Advisory Committee in October of last year, that is 2020, to the National Police Service. That directive having to do with the conduct of public gatherings and was intended to cure, and I quote from the directive, the weaponization of public gatherings. Now, this is what the court has decided, and Justice Anthony Mrima, who was presiding over that case, has said that has quashed the directive, I beg your pardon, on the grounds that only the Director of Public Prosecutions and not the executive can instruct the National Police Service to take a particular course of action. He, however, fell short of declaring as unconstitutional Section 5 of the Public Order Act, Cap 56, on which the directive was grounded. That directive having been issued on October the 7th, 2020 by the National Security Advisory Committee and ratified the next day by Cabinet. He has, however, prohibited the Inspector General of Police, or any police officer for that matter, from taking orders from the National Security Advisory Committee on how they should carry out their duties. The petition was lodged by the Law Society of Kenya and has succeeded in part, the LSK having accused the executive of breaking the law under the cover of containing the spread of the coronavirus disease. The directive in question required those who chose to attend public gatherings not to propagate insurgency and socio-economic hostility among Kenyans. It also threatened to hold liable broadcasters for the airing of such content, and social media users were also threatened with consequences for disseminating such content, with social media admins, I should say, instructed to control undesirable content and discussions on their platforms. Okay, you will recall that some viewed that directive as an attempt to criminalize the hustlers versus dynasties